Tonight, we examine a case that once occupied the attention of an entire county and then slipped quietly into the historical record. A single investigation, a single file, a case that history very nearly forgot. The case of Rose Harsent begins in Peasenhall, Suffolk, in the spring of 1902. Peasenhall was a small rural village in the east of Suffolk, set among the flat agricultural land that characterised much of the county at the turn of the century. The village was home to only a few hundred residents, and its economy rested largely on agriculture and on a single significant local employer, the firm of Smyth and Sons, manufacturers of seed drills and other agricultural machinery. The work stood along the main street and provided employment to a portion of the village's male population, giving Peasenhall a modest industrial character within an otherwise farming landscape. The main thoroughfare through the village was lined with cottages, shops, and a scattering of larger houses belonging to the more established families of the parish. Religious life in Peasenhall centred on its chapels rather than its parish church, reflecting the strength of nonconformist worship across much of rural Suffolk in this period. The Primitive Methodist chapel, standing in the neighbouring village of Sibton, but drawing much of its congregation from Peasenhall men, held a central place in the social and moral life of the community, and standing within its congregation carried real weight among neighbours. A Wesleyan Methodist chapel in Peasenhall, known locally as the Doctor's Chapel, remained in use for worship and was attended by Georgiana Crisp. Village life in Peasenhall at this date moved according to the rhythms of the agricultural calendar, the working hours of the seed drill works, and the observances of chapel attendance. Reputation was closely guarded in a community of this size, where a family standing depended on regular attendance at worship, steady employment, and the absence of scandal. Rumour travelled quickly along the main street and through the works, and a suggestion of impropriety was not easily forgotten, even when no formal charge followed it. Providence House stood along this same main street, the residence of William and Georgiana Crisp, a settled local family who employed domestic help in the manner customary for households of their standing. It was into this household that Rose Harsent had come to work as a domestic servant, living in under the Crisps' roof in the manner expected of an unmarried young woman of her class. Her attic bedroom lay at the top of a staircase that descended to the kitchen below, a staircase that would become the central scene of the case that followed. It was into this quiet, close-knit, chapel-going community where a servant girl's conduct was watched as closely as any other residence that Rose Harsent's life and death were set. Rose Anne Harsent was the daughter of William Gardiner, a labourer employed in and around Peasenhall, described in the surviving record as a working man of the parish. The documentary record available for this account does not establish details of Rose's mother, her siblings, or the particulars of her early childhood with any certainty, and no birth date for her has been established in the sources examined for this account. What the record does establish is that by the year 1902, she was a young, unmarried woman, generally placed at 22 years of age, working as a domestic servant in the household of William and Georgiana Crisp at Providence House in Peasenhall. Domestic service was among the most common forms of employment available to young, unmarried women of Rose's background during this period. A position as a resident servant provided lodging, a wage, and a measure of security, but it also placed a young woman under close and constant observation, both by her employers and by the wider village in which she lived. Reputation was, for a servant in Rose's position, closely tied to her prospects. A young woman known to be respectable, hardworking, and of good character could expect her position to remain secure and her standing in the community to remain intact. Any suggestion to the contrary carried consequences that extended well beyond a single household. The surviving record consistently describes Rose Harsent as a respectable and well-regarded servant in Peasenhall prior to the events of 1902. She was known in the village, attended chapel, and was accepted as a young woman of good standing within the small community in which she lived and worked. It was against this background of an ordinary, unremarkable position in village life that rumour began to attach itself to her name, roughly a year before her death. Rumour that centred not on any fault in her work or her conduct as a servant, but on an alleged connection to a married man of standing within the same chapel community in which she herself worshipped. That man was William Gardiner, a foreman at the Smyth and Sons seed drill works and a leading lay figure within the Primitive Methodist congregation of Sibton. Gardiner was a married man, the father of 6 children, and his wife, Georgiana Gardiner, shared the family home in a semi-detached cottage along the main street of the village, within sight of Providence House itself. His position at the seed drill works placed him among the more established working men of the parish, and his standing within the chapel congregation gave him a further measure of respectability within a community where chapel life carried significant social weight. The precise nature of his role within the chapel is not established with certainty in the surviving sources, some describing him in terms of leadership over the choir, others in terms of a broader position of responsibility within the congregation's affairs. What is consistently established is that he held a position of some prominence and trust within the Primitive Methodist community of Sibton, a position that made the rumours that later attached to his name all the more consequential for the village that had placed that trust in him. This story begins in an ordinary village, much like countless others. Roughly a year before Rose Harsent's death, rumours began to circulate in Peasenhall, suggesting an improper association between her and William Gardiner. The rumours centred on an alleged sighting of the two together in the vicinity of the Doctor's Chapel, the disused Wesleyan outbuilding standing apart from the main chapel in regular use. The precise origin of the rumour is not established with certainty in the surviving record, but its effect within the village was immediate and considerable. In a community as small and as closely observed as Peasenhall, a suggestion of this kind involving a married man of standing and a young unmarried servant could not remain confined to private conversation for long. The matter reached the attention of the Reverend John Guy, who conducted an inquiry within the Primitive Methodist congregation into the truth of the rumours. The inquiry examined the accounts of those who claimed to have witnessed some impropriety between Gardiner and Harsent, but it reached no conclusive finding, either confirming or dismissing the allegations. No formal charge followed from this inquiry, and the matter did not proceed beyond the internal affairs of the congregation. William Gardiner, for his part, is recorded as having threatened legal proceedings against those responsible for spreading the rumour, a response consistent with a man seeking to protect his standing within the community rather than one facing a substantiated accusation. The inquiry closed without resolution, and outward village life appeared for a time to resume its ordinary course. The rumour did not disappear from village memory, however, even as no further formal action followed it. It remained a subject of quiet local knowledge, the kind of matter that a small community does not forget even when it ceases to discuss it openly. Rose Harsent continued in her position at Providence House, and William Gardiner continued in his position at the seed drill works and within the chapel congregation. The unresolved question of what, if anything, had passed between them settled into the background of village life, unremarked upon but not forgotten, until the events of the following year returned it to the forefront of local attention under circumstances considerably more serious than the original rumour had ever suggested. By the spring of 1902, Rose Harsent was 6 months pregnant. The paternity of the child she carried was never established as a matter of legal record, though the earlier rumours involving William Gardiner meant that suspicion within the village, and later within the formal investigation that followed her death, turned toward him as a possible father. An unmarried pregnancy carried severe social and economic consequences for a young domestic servant in this period. Loss of a position, loss of a wage, and a lasting mark upon her reputation within a small community were all realistic prospects facing a woman in Rose's circumstances. And the record establishes that this was the situation in which she found herself in the final months of her life, though the record does not establish with certainty what plans, if any, she had made in response to it. Central to the events that followed was an unsigned note, later recovered and entered into the case as evidence. The note read as an arrangement for a secret meeting at midnight, instructing its recipient to place a light in a window at 10 o'clock for a period of about 10 minutes as a signal, after which the writer would attempt to see her at midnight at her place. This note became the single most significant piece of documentary evidence tied to the events of the night of Rose Harsent's death, and its authorship became a central point of dispute at the trials that followed. Handwriting analysis was later presented at trial in an attempt to connect the note to William Gardiner, though this analysis was contested by the defence, and the note's authorship was never established beyond dispute in either of the two trials that examined it. On the night of the 31st of May, 1902, a severe thunderstorm passed over Peasenhall. It was during this storm, and around the hour named in the note recovered, after her death, that Rose Harsent's movements on the final night of her life are placed by the surviving record. She'd carried out her ordinary domestic duties at Providence House that day, in keeping with her established routine within the Crisp household, and nothing in the record suggests any deviation from her usual conduct in the hours preceding the appointment the note described. The household at Providence House retired for the night in the ordinary course, unaware of what the coming hours would bring. It fell to William Harsent, Rose's father, to discover what had become of his daughter. On the morning of the 1st of June, 1902, he came to Providence House, and there found Rose lying at the foot of the staircase leading from the kitchen to her attic bedroom. She was dead, and had been so, by later estimation, for approximately 4 hours, a period of time consistent with the hour of midnight, named in the note recovered from the scene. The discovery of her body at the foot of that staircase, in the household where she had lived and worked, marked the end of the ordinary course of village life in Peasenhall and the beginning of an investigation that would occupy the attention of the county and in time the nation for the better part of the following year. The circumstances in which she was found made clear from the outset that no ordinary accident had befallen her. Her injuries and the state in which her body and the surrounding scene were discovered pointed unmistakably toward violence rather than misadventure, and the household's alarm on the morning of the 1st of June set in motion the sequence of official proceedings, examinations, and inquiries that would follow in the weeks and months ahead. The alarm raised at Providence House on the morning of the 1st of June brought the local constabulary to the scene without delay. Officers were dispatched from the surrounding district, and the household was secured while the body of Rose Harsent remained at the foot of the staircase, pending examination. The kitchen itself bore signs of the events of the preceding night. A paraffin lamp lay broken near where she had fallen, and it became apparent to the officers on the scene that some attempt had been made to set her nightdress alight, an attempt that had scorched but had not consumed the body before it was discovered. A bottle that had contained paraffin was recovered from the scene, bearing a handwritten label reading, "For Mrs. Gardiner's children," a label that would come to occupy a central place in the case that followed, tying an object found beside the body to the household of the man already once suspected of an association with her. The officers examining the scene noted immediately the direction the evidence seemed to point. The recovered note arranging a midnight meeting through a signal of light in a window was found among Rose's belongings or near the place where she was discovered. The surviving accounts differing slightly on the precise circumstance of its recovery but agreeing on its content and its significance, investigators moved quickly to secure this note as evidence, recognizing in its arrangement of hours and signals a direct connection to the estimated time of death established by the condition of the body. Statements were taken from members of the Crisp household, from William Harsent, and from neighbours in the vicinity of Providence House regarding any sounds, lights, or movements observed on the night of the storm. Word of the rumours from the previous year reached the investigating officers within a short time of the discovery, and this earlier history between Rose Harsent and William Gardiner shaped the direction of the inquiry from its earliest hours. Investigators sought out those villagers who had spoken, the year before, of an impropriety observed near the doctor's chapel, and took fresh statements from them in light of what had now occurred. The inquiry conducted within the Primitive Methodist congregation by the Reverend John Guy was recalled, and its findings, inconclusive as they had been, were set against the new and far graver circumstances now before the police. Officers proceeded to Gardiner's cottage along the main street, a short distance from Providence House, and it was there that his position within the village and his connection to the case were first formally examined by the investigating authorities. His household was questioned, and his wife, Georgiana Gardiner, gave an account placing her husband at home throughout the night in question. This alibi, offered in the earliest days of the investigation, would remain a central and contested feature of the case through both of the trials that followed, its reliability never settled to the satisfaction of either jury that examined it. The handwriting on the recovered note was subjected to examination in an effort to establish its author. Specimens of William Gardiner's handwriting were obtained and compared against the note by those engaged to give an opinion on the matter, though the conclusions reached were not uniform and would themselves become a matter of dispute when the case came before the courts. Investigators also turned their attention to the paraffin bottle and its label, seeking to establish how such an item, marked in a manner connecting it to the Gardiner household, had come to be found beside Rose Harsent's body. No satisfactory explanation for its presence at the scene was produced that exonerated the household to which the label referred, and this object remained throughout the investigation and the trials that followed one of the most closely examined pieces of physical evidence in the case. Neighbours in the vicinity of Providence House and of Gardiner's own cottage were asked whether they had observed any person abroad during the storm of the 31st of May, given the lateness of the hour and the severity of the weather that night. The heavy rain and thunder that had marked the night in question complicated this line of inquiry considerably, since few residents had reason to be out of doors or looking from their windows during such conditions, and those who were questioned offered little that could firmly place any particular individual on the street between Gardiner's cottage and Providence House at the hour named in the recovered note. This absence of a clear eyewitness account of movement between the two houses became in time one of the more significant gaps in the case that investigators were required to build. As the investigation proceeded through the early days of June, the rumours of the previous year, the recovered note, the paraffin bottle bearing its handwritten label, and the alibi offered by Georgiana Gardiner formed the principal strands of evidence upon which the police case against her husband was constructed. On the 3rd of June 1902, William Gardiner was arrested and taken into custody 2 days after the discovery of Rose Harsent's body at the foot of the staircase in Providence House. His arrest marked the formal conclusion of the initial investigative phase and the beginning of the committal proceedings that would, in due course, bring the case before the Suffolk Assizes at Ipswich. Following his arrest, William Gardiner was brought before the local magistrates, and after committal proceedings, examined the evidence assembled by the investigating officers, was ordered to stand trial at the Suffolk Assizes. Before the case reached that court, however, the body of Rose Harsent was subject to formal medical examination, and a coroner's inquest was convened to determine the circumstances of her death as a matter of law, separate from and preceding the criminal proceedings that would follow. The medical examination of Rose Harsent's body established that she had died as a result of a cut to the throat, with further wounds to the shoulders, injuries the examining physician determined to have been rapidly fatal. The examination further established that she had been approximately 6 months pregnant at the time of her death, a finding recorded as part of the post-mortem process and entered into the record that would be placed before both the coroner's inquest and the criminal trials to follow. The name of the physician who conducted this examination is not established with certainty in the surviving record, though the findings themselves, the cause of death and the fact of the pregnancy, were consistently reported across the accounts of the proceedings that followed. The coroner's inquest into the death of Rose Harsent was convened in Peasenhall in the days following the discovery of her body, in keeping with the ordinary legal requirement that a sudden and violent death be examined by a coroner and a jury drawn from the local district. Witnesses were called before this inquest, including members of the Crisp household, William Gardiner, and those who had given statements to the investigating police regarding the rumours of the previous year and the events of the night in question. The precise wording of the verdict returned by the coroner's jury is not established with certainty in the surviving record, but the proceedings concluded in a manner that supported the committal of William Gardiner to stand trial at the assizes, the inquest's findings aligning with the direction the police investigation had already taken. The inquest, in the manner customary for proceedings of this kind, served principally to establish the fact and manner of death as a matter of public record and to determine whether the evidence available warranted a criminal trial. Having concluded that it did, the coroner's proceedings gave way to the formal processes of the criminal courts, and the case passed from the hands of the local constabulary and coroner into those of the barristers and judges who would examine it at Ipswich. The village of Peasenhall, having furnished its witnesses and its testimony to the inquest, now waited upon the outcome of a trial that would draw upon it a degree of public attention far beyond what its ordinary situation as a small agricultural parish might have anticipated. The first trial of William Gardiner opened at the Suffolk Assizes in Ipswich on the 7th of November 1902 before Sir William Grantham. The prosecution was led by Henry Fielding Dickens, son of the novelist Charles Dickens, and the defence was conducted by Ernest Wilde. Over the course of 4 days, the court heard evidence concerning the recovered note, the paraffin bottle bearing its label naming the Gardiner household, the handwriting comparisons undertaken in the course of the investigation, and the alibi offered by Georgiana Gardiner for her husband's whereabouts on the night in question. The earlier rumours of an impropriety near the doctor's chapel and the inconclusive inquiry conducted by the Reverend John Guy were also placed before the jury as part of the wider history the prosecution sought to establish between the accused and the deceased. Character evidence regarding William Gardiner's standing within the Primitive Methodist congregation and his position at the seed drill works was presented to the jury, evidence intended by the defence to demonstrate the respectability and settled family life of a man they maintained had no part in the crime charged against him. The prosecution, for its part, pressed the significance of the note, the label on the paraffin bottle, and the handwriting evidence, as together establishing a connection between the accused and the circumstances of Rose Harsent's death that could not be explained by coincidence. Cross-examination of the witnesses touched repeatedly upon the reliability of Georgiana Gardiner's account of her husband's presence at home throughout the night of the storm, an account upon which the defence's position rested heavily. After the close of evidence and the addresses of counsel, the jury retired to consider its verdict. After a period of deliberation, the jury returned unable to reach the unanimous verdict required by law, standing at 11 in favour of conviction to 1 for acquittal. Sir William Grantham discharged the jury, and the case was accordingly set down for a second trial, the first proceeding having concluded without a verdict, despite the substantial majority the jury had reached in favour of guilt. The second trial of William Gardiner opened at the Suffolk Assizes in Ipswich on the 20th of January 1903, before a different judge, Sir John Compton Lawrence. Henry Fielding Dickens, again led the prosecution, and the same body of evidence was placed before a newly empanelled jury. The note, the paraffin bottle and its label, the handwriting comparisons, the history of rumour reaching back to the previous year, and the alibi given on Gardiner's behalf by his wife. The proceedings covered much of the same ground as the first trial, though counsel on both sides had, by this second hearing, refined their arguments in light of the points that had proven most persuasive or most vulnerable before the earlier jury. The defence pressed with particular emphasis upon the uncertainty surrounding the handwriting evidence, arguing that no examiner had established with the certainty the charge required that the note found near Rose Harsent had been written by the hand of the accused. Ernest Wilde returned to represent Gardiner, and his cross-examination of the prosecution's witnesses concerning the note's authorship occupied a significant portion of the proceedings. The prosecution maintained that the combination of the note, the label naming the Gardiner household, and the history of rumour between the accused and the deceased was sufficient, taken together, to establish guilt beyond the standard the law required, even where no single piece of evidence stood alone as conclusive. Witnesses from Peasenhall were again called to give their accounts of the rumours of the preceding year, of the inquiry conducted within the chapel congregation, and of the movements and observations of the night of the 31st of May. The severity of the storm that had marked that night was again raised in relation to the absence of any eyewitness, placing William Gardiner on the street between his cottage and Providence House, at the hour named in the note. Georgiana Gardiner once more gave her account of her husband's presence at home throughout the night, an account that remained, as it had at the first trial, central to the defence's case and impossible for the prosecution to disprove through any direct contradicting testimony. At the conclusion of the evidence and the closing addresses of counsel, the jury retired a second time to consider its verdict in the case. After further deliberation, the jury again returned unable to agree, this time standing at 11 in favour of acquittal to 1 for conviction, a reversal of the near unanimous position reached by the jury at the first trial some 2 months before. Sir John Compton Lawrence discharged this second jury as he had been required to do, the law of the period permitting no verdict to stand save by unanimous agreement of all 12 members. Following this second disagreement, the matter of whether to proceed to a third trial rested with the Crown. Henry Fielding Dickens, having led the prosecution through both hearings, determined that a further trial should not be pursued, and a nolle prosequi was entered, formally discontinuing the prosecution of William Gardiner for the murder of Rose Harsent. This step brought the criminal proceedings to a close without either a conviction or a formal acquittal being recorded against him. William Gardiner was accordingly released from custody, a free man in the eyes of the law, though the entry of a nolle prosequi carried with it no finding that he had not committed the offence with which he had been charged, only that the Crown had elected not to press the matter further before a third jury. The reversal between the two juries, the first standing 11 to 1 for conviction and the second 11 to 1 for acquittal, was noted at the time as a singular feature of the case, and it has remained one of the most closely examined aspects of the Peasenhall proceedings in the years since. No explanation for this reversal was offered as part of the official record of either trial, the workings of a jury's deliberations lying beyond the reach of the court's published proceedings, and the surviving accounts of the case do not establish what considerations moved the second jury toward a conclusion so markedly different from the first. The public reaction to the outcome of the second trial was considerable, and the case continued to command attention in the national press for some time after the proceedings at Ipswich concluded. A respected figure within a nonconformist chapel congregation, a foreman holding a position of responsibility at a local manufacturing works, had stood twice accused of the murder of a young pregnant servant with whom he had been rumoured to be improperly connected, and the case's resolution, if it could be called a resolution at all, satisfied neither those who believed firmly in Gardiner's guilt nor those who maintained his innocence. Newspapers across the country carried accounts of the two trials and their contrasting verdicts, and the case was widely discussed as an illustration of the difficulty the law faced in cases resting so heavily upon circumstantial evidence, however numerous the individual strands of that evidence might be. No sentence was ever passed in connection with the death of Rose Harsent, since no conviction had been secured against any person. The entry of a nolla prosequi brought the prosecution to a formal close without resolving the question of who had been responsible for her death, and no further arrest or charge followed in relation to the case. William Gardiner returned to Peasenhall following his release, but the village that had furnished the witnesses, the rumours, and the jurors of local acquaintance to two trials proved unable to offer him or his family a settled place within it. Gardiner and his wife, Georgiana, together with their 6 children, are recorded as having left Peasenhall in the period following his release, unable to remain in a community that had spent the better part of a year examining the question of his guilt in open court. The later course of William Gardiner's life away from Peasenhall is not established with certainty in the surviving record. Some accounts suggest that he lived quietly, away from public attention, for the remainder of his years, and that he died in 1941, though the particulars of where he settled and how he occupied himself in the decades following his departure from Suffolk are not established with the confidence that would allow them to be stated here as fact. What is established is that he did not return to live in Peasenhall, and that the case which had made his name known across the country followed him, in reputation, if not in law, for the rest of his life. Rose Harsent's father, William Harsent, who had discovered his daughter's body at the foot of the staircase on the morning of the 1st of June, remained a resident of Peasenhall in the years that followed, a figure connected in the memory of the village to the events of that year in a manner he had not sought and could not escape. The record does not establish further particulars of his life following the conclusion of the trials, nor of any other members of Rose Harsent's family, beyond his role in the discovery of her body and his testimony before the coroner's inquest and the criminal courts. The case of Rose Harsent did not pass from public attention with the entry of the Noll Prosequi in 1903. A volume in the notable British Trials series was later devoted to the proceedings, preserving the transcripts and evidence of both trials for the study of subsequent generations of lawyers and historians examining the case. The case has since been the subject of further published accounts, including a modern history titled The Peasenhall Murder, part of a series devoted to unsolved cases of the period, and a separate work by Neil Norman examining the case under the title The Peasenhall Murder, an Edwardian Mystery. The writer John Dickson Carr is reported to have drawn upon the case as inspiration for his short story, Blind Man's Hood. In more recent years, the British Broadcasting Corporation produced an episode of the programme Julian Fellows Investigates, devoted to the case, a modern television examination that advanced the theory that Georgiana Gardiner, rather than her husband, might have been responsible for Rose Harsent's death, a theory arising from 21st century speculation about the case, rather than from any finding of the original investigation, inquest or trials, and one that has no standing in the historical evidentiary record of 1902 and 1903. The case of Rose Harsent has continued to be examined for the light it casts upon the workings of the criminal justice system of Edwardian England, and in particular upon the requirement, then in force, that a criminal jury reach a unanimous verdict before any conviction could stand. The two trials of William Gardiner, resulting in juries divided in opposite directions upon substantially the same evidence, have been cited repeatedly as an illustration of the uncertainties inherent in a case built upon circumstantial connections rather than direct proof, however numerous and however suggestive those connections might appear when set before a court. Peasenhall itself, a small agricultural village of a few hundred residents at the turn of the century, found itself for a period the subject of national attention entirely disproportionate to its ordinary situation, its chapel, its seed drill works, and its main street becoming, for a time, known across the country as the setting of a murder that no court was ever able to resolve. The social conditions that shaped the case were themselves characteristic of rural Suffolk at the turn of the century. Domestic service remained the common occupation for young unmarried women of Rose Harsent's background, carrying with it both a measure of security and a considerable vulnerability, particularly where an unmarried pregnancy placed a servant's position and reputation at risk. The strength of nonconformist chapel life in villages such as Peasenhall meant that questions of personal conduct and reputation carried a weight extending well beyond the private affairs of those concerned, drawing in the wider observance and judgment of the congregation, and in time, of the criminal courts themselves. It was within this setting of chapel and cottage, of seed drill works and quiet village street, that the case of Rose Harsent unfolded, and it was within this same setting that it was ultimately left unresolved, its central question never answered by any court that examined it. The seed drill works of Smyth and Sons stood as the largest single employer within Peasenhall at the turn of the century, its workshops and yards occupying a significant portion of ground along the village's main thoroughfare. The firm had built its reputation over several decades on the manufacture of agricultural drilling machinery, equipment sold to farms across East Anglia and beyond, and its presence gave Peasenhall an industrial character uncommon among villages of its size in rural Suffolk. Men employed within its workshops held a measure of steady wage and standing not always available to those dependent solely upon the uncertain seasonal work of the surrounding farms. And a position of foreman within such a works, the position held by William Gardiner, carried with it a recognised standing among the working families of the parish. The rhythm of the working day at the seed drill works, beginning early and structured around the demands of manufacture and dispatch, shaped the pattern of village life alongside the older rhythms of the agricultural calendar that continued to govern the surrounding farms. Wages earned within the works supported households along the main street and in the cottages and lanes surrounding it. Households that in turn depended upon domestic servants such as Rose Harsent to manage the daily labour of cooking, cleaning and household maintenance that a family of any standing required. The presence of resident servants within houses such as Providence House was itself a marker of a household's position within the modest social hierarchy of a village of this size, a hierarchy in which the Crisp family, employers of a resident domestic servant, stood somewhat apart from labouring families who could not afford such help. Chapel attendance on a Sunday drew together, within the walls of the Primitive Methodist chapel, a congregation spanning much of this same social range. Labourers and foremen, servants and employers gathered under a single roof in a manner the working week did not otherwise permit. It was within this gathering that reputation was most visibly measured, where a family's regularity of attendance, its conduct, and its standing among neighbours were observed and quietly assessed from one week to the next. A position of prominence within this congregation, such as that held by William Gardiner, was not merely a matter of religious observance but a public marker of trustworthiness within the wider life of the village, a trust that extended into his dealings at the seed drill works and into the wider regard in which his family was held along the main street where they lived. For a young woman in domestic service such as Rose Harsent, this same close observation carried a different weight. Her conduct, her attendance at chapel, and her standing among the households of the village were similarly watched, but with far less margin for error or misfortune than was extended to a married foreman of established position. A servant's wage was modest, her lodging tied entirely to her continued employment, and her prospects for the future dependent upon a reputation that could be undone by rumour alone, without any formal finding of wrongdoing ever being made against her. It was this asymmetry between the standing a man such as Gardiner could call upon to weather an unproven rumour and the vulnerability a servant such as Harsent faced from the same unproven rumour that shaped the way the village of Peasenhall received the news of the events of the 31st of May and the 1st of June 1902, and shaped in turn the year of public scrutiny that followed for all those drawn into the case. Ipswich itself, the county town where both trials of William Gardiner were held, stood at some distance from Peasenhall, a market and county administrative centre of considerably greater size than the village at the heart of the case, and it was to its assize court that witnesses, jurors, and members of the public travelled from the surrounding countryside over the course of the two hearings. The Suffolk Assizes sat within a courtroom built to accommodate the ordinary business of county justice, and the volume of public and press interest drawn by the Peasenhall case placed considerably greater demand upon its seating and its galleries than the court's routine calendar of civil and criminal matters ordinarily required. Correspondents from the London papers travelled to Ipswich to report upon the proceedings, and their dispatches carried the details of the case, the recovered note, the paraffin bottle, the chapel rumours, and the testimony of Georgiana Gardiner to readers across the country who had no other connection to Suffolk or to the village of Peasenhall itself. The distance between Peasenhall and Ipswich meant that witnesses called before the court, many of them villagers with no experience of appearing before a judge and jury, faced a journey and an ordeal considerably removed from the ordinary pattern of their working lives. Farm labourers, chapel members, and household servants who had never before stood in a witness box found themselves questioned and cross-questioned by barristers of the standing of Henry Fielding Dickens and Ernest Wilde. Their accounts of rumour, of lights glimpsed through storm-darkened windows, and of conversations recalled from a year or more before, tested and retested across the length of two separate trials. The strain this placed upon a small community, called upon twice within the space of a few months to furnish its witnesses and to see its private affairs examined in a public courtroom many miles from home, was considerable, and it left its mark upon Peasenhall long after the Assize Court at Ipswich had concluded its business in the case. The rural county of Suffolk in which both Peasenhall and Ipswich stood was at the turn of the century a landscape still overwhelmingly given over to agriculture, its market towns serving as the principal points of exchange between the farming villages of the surrounding countryside and the wider commercial and administrative life of the county. Ipswich, as the county town, held the assize court, the principal newspapers, and the administrative offices through which a case of this gravity necessarily passed, while villages such as Peasenhall remained dependent upon these larger centres for the machinery of law that a matter such as the death of Rose Harsent required. It was this relationship between a small chapel-going farming village and the county town some miles distant that held its courts and shaped its newspapers, that carried the case of Rose Harsent from the kitchen stairs of Providence House to a national audience, and that left the question of her death recorded, examined, and ultimately unresolved within the assize records of Suffolk for more than a century that followed. The requirement of unanimity that governed both juries at Ipswich was, in this period, an absolute one, a rule of English criminal law that permitted no verdict to be received from a jury divided in its opinion, however narrow that division might be. A jury retiring to consider its verdict was, under the practice of the assize courts of the time, kept together without separation until either an agreement was reached or the presiding judge was satisfied that no such agreement could be achieved within a reasonable period of continued deliberation. The 12 men who sat upon each of the two juries that examined the case against William Gardiner were drawn from among the qualified jurors of the county, property-holding men of Suffolk, called to serve at the assizes as the ordinary business of the court required, and their deliberations in a case of this gravity, carrying with it the prospect of a capital sentence, should a verdict of guilty be returned, were understood by judge and counsel alike to warrant whatever period of consideration the jury required. The first jury's deliberation, in November of 1902, concluded with 11 members prepared to convict and a single member withholding agreement, a division that fell one vote short of the unanimous verdict the law demanded, regardless of how emphatic the majority in favour of conviction might have been. Sir William Grantham, upon being satisfied that no further deliberation would resolve this single dissent, discharged the jury from further consideration of the case, a discharge that left the matter formally undetermined and set the stage for the second trial that followed some 10 weeks later. The single juror whose dissent prevented a verdict of guilty from being returned in November of 1902 has not been identified in the surviving record, nor has any account survived of the reasoning that led that one member of the jury to withhold agreement from the 11 who were prepared to convict. The second jury, convened in January of 1903 before Sir John Compton Lawrence, arrived at a division reversed from the first. 11 members prepared to acquit against a single member unwilling to agree to that verdict, a reversal that left the case no closer to a settled legal conclusion than it had been after the first trial's disagreement 2 months before. This second jury's deliberation, conducted over evidence substantially the same as that placed before the first, produced a result that has drawn the particular attention of those who have since examined the case: the near total reversal of one 12-member jury's assessment by a second jury considering the same body of testimony within the space of a single winter. Sir John Compton Lawrence, as his predecessor had done in November, discharged this second jury upon being satisfied that its members could reach no unanimous agreement, bringing to a close the second and, as it transpired, the final attempt to try William Gardiner before a jury of his countrymen for the death of Anne Harsent. The decision to enter a nolle prosequi rather than proceed to a third trial rested with the Attorney General's Department, acting through the prosecuting counsel, and represented a specific and relatively uncommon instrument within English criminal procedure of the period. A nolle prosequi carried no legal effect equivalent to an acquittal, and it left the accused in a position distinct from one who had been tried a third time and found not guilty by a jury's unanimous verdict. Where an acquittal would have brought the proceedings to a close, with a formal finding recorded in William Gardiner's favour, the entry of a nolle prosequi instead brought the prosecution to an end without any such finding being made, a discontinuance rather than a determination, leaving the question of guilt or innocence formally unresolved in the eyes of the law, even as it released the accused from further jeopardy in respect of the charge. The reasoning behind the Crown's decision not to pursue a third trial was not set out at length in the surviving record of the proceedings, though the pattern of the two juries already convened, one dividing sharply toward conviction and the second dividing just as sharply toward acquittal, offered the prosecuting authorities little assurance that a third jury would arrive at any more settled conclusion than the first two had done. The expense and public strain of two lengthy assize trials, each requiring witnesses to travel from Peasenhall to Ipswich, and each drawing correspondence from across the country to report upon the proceedings, weighed also upon a decision of this kind, though the surviving record does not establish with certainty what balance the Attorney General's Department struck between these considerations in reaching its final determination not to proceed further. Gardiner's release from custody following the entry of the nolle prosequi in 1903 accordingly carried with it no formal exoneration, a distinction that shaped the manner in which both the press of the period and the village of Peasenhall itself received the news that no further trial would be held. A man released without a verdict of not guilty having been returned in his favour remained, in the practical estimation of many who followed the case, a figure under a cloud that no legal instrument could entirely lift, whatever protection the law itself extended to him against any further prosecution for the same offence. It was this unresolved quality, a release without acquittal, a discontinuance without determination that has left the case of Rose Harsent, recorded in the history of English criminal law, as a matter formally closed and yet substantively unanswered, its central question never settled by the courts that examined it, across the two trials held at Ipswich in the winter of 1902 and the early weeks of 1903. No arrest was ever made. The investigation was formally closed. The case remains open. The record remains incomplete. That is where the record of the first case ends. What follows is a second account, quieter than the one before it, drawn from a much thinner archive, concerning a household in another part of London, and another kind of question that was never closed. The particulars are fewer here, and the record itself grows sparse in places, but what survives has been set down as it was found. The case of Rachel Samuel begins in Bloomsbury, London, in December of 1878. Bloomsbury, in that period, occupied a settled and respectable position within the wider geography of the capital, a district of regular Georgian and Regency terraces laid out in squares and crescents, home to professionals, retired tradespeople, and widows of independent means who had taken houses there for the quiet of the streets and the proximity of the city beyond them. Burton Crescent, where Rachel Samuel resided at number 4, had been built between 1809 and 1811 as part of the Skinner's Company estate, a curved terrace of brick townhouses with iron railings and pillared doorways, designed for households that kept at least one servant and expected to be left in peace. By the late 1870s, the Crescent retained much of its original character. Though London itself had grown considerably around it, the city's population, by this date exceeding 4 million, its streets increasingly lit by gas, its traffic increasingly dense with omnibuses, cabs and delivery carts moving between the residential squares of Bloomsbury and the commercial districts to the south and east. The winter of 1878 in London was a season of short days and long darkness, the kind of December in which householders lit their lamps before 4 in the afternoon and kept fires burning through the evening against the cold and the damp that settled over the city from the river. A house such as the one at Burton Crescent would have been heated by coal fires in the principal rooms, lit by gas or oil lamp in the passages and kitchen, and secured each night with locks and bolts that were, in a respectable residential crescent, generally regarded as sufficient. The kitchen of such a house occupied the basement or semi-basement level, reached by a service stair, and served as the working centre of the household, the place where a resident could be found at almost any hour of the day, attending to the ordinary business of keeping house. It was in this room, in December of 1878, that Rachel Samuel was found beaten to death. Rachel Samuel was 74 years of age at the time of her death. She is recorded as a widow, living alone at number 4 Burton Crescent, a woman evidently of sufficient means to maintain a household of her own in a respectable part of London. Her name appears in some accounts as Rachel Samuel, the two spellings used interchangeably in the surviving record, though Rachel is the form more commonly preserved and is used throughout this account. Beyond her age, her marital status, and her residence, very little of her earlier life survives in the documentation available. No record of her parents, her place of birth, the date of her marriage, or the circumstances of her widowhood has been established. What can be said is that by 1878 she belonged to a recognisable class of late Victorian London householder, the elderly widow of independent means, a woman who had outlived a husband and continued to occupy her own residence, rather than moving into the household of relatives. A common enough arrangement among women of her generation who possessed the property or income to sustain it. Such women were, in the domestic economy of the period, entirely ordinary. Domestic service was a near universal feature of households of this class, and a widow living alone would typically employ at minimum a single servant to perform the cooking, cleaning, and household management that a woman of Rachel Samuel's age and standing would not have been expected to undertake herself. The employment of servants in such circumstances created a particular pattern of intimacy and dependency, within the household, the servant privy to the routines, habits, and possessions of an employer who in turn depended on that same servant for the daily functioning of the house. It was within this arrangement that Rachel Samuel had, at some point prior to December of 1878, employed a woman named Mary Donovan. The nature and duration of Mary Donovan's employment in the Samuel household is not established with precision in the surviving record. She is described as a former servant of Rachel Samuel, a phrase that indicates her period of employment had concluded by the time of the murder, though whether this separation had occurred weeks, months, or years earlier is not documented, nor is it recorded whether she left the position on her own initiative, was dismissed, or departed under some other circumstance. What is documented is that she had, at some point, occupied a position within the household that would have given her knowledge of its routines, its layout, and the habits of the woman who lived there. No stressors, disputes, or specific precipitating events in the period immediately before the murder have been established in the sources available for this account, and none should be assumed. Rachel Samuel's situation in December of 1878, then, was that of an elderly widow living alone in a respectable Bloomsbury house. A woman of evident if modest means, attended at some point in the past by a servant who was no longer in her employment. The record does not preserve whether she had, by December of 1878, engaged a replacement servant, nor does it establish the particulars of her daily routine, her social circle, or her activities in the days preceding her death. This absence of detail is itself characteristic of the case as a whole. Unlike murders that drew sustained national attention, generating extensive newspaper coverage, published trial transcripts, and later book-length treatments, the case of Rachel Samuel survives chiefly in brief period summaries and later compilations of London's unsolved crimes, the kind of case that received its due notice at the time and was then permitted to recede from public memory, its details never expanded upon by the kind of sustained documentary attention given to more notorious contemporaries. If you find value in histories preserved this way, consider liking the video and subscribing to the channel. Now back to the record. The circumstances leading to the murder of Rachel Samuel are, in the surviving documentation, confined to the essential facts of her residence, her age, and her prior connection to Mary Donovan. No account survives of her movements in the days before her death, of visitors to the house, of any disturbance or dispute reported by neighbours, or of any change in her circumstances that might be read as a precipitating factor. This absence should not be read as evidence of anything in particular. Many domestic murders of the period, particularly those that were never solved, generated only a limited documentary record, even at the time. The local press reporting the discovery of the body and the subsequent arrest of a suspect without the kind of sustained investigative journalism that characterised the more prominent cases of the era. What can be established is that Rachel Samuel remained in her house at Burton Crescent through the early part of December of 1878, that she was, so far as the record shows, alone in the property, or largely so, and that at some point during that month she was attacked in the kitchen of her own home. The kitchen, as the working centre of a Victorian household, was a room in which a woman of Rachel Samuel's age and position might reasonably be found at most hours of the day, engaged in the ordinary business of preparing food, tending a fire, or attending to household stores. It was not a room associated with particular vulnerability in the way a bedroom or a street might be considered, but rather a room in which the household's routines were conducted in full expectation of privacy and safety. The attack upon Rachel Samuel took place within this space, a location that speaks to an assailant either already present within the house or admitted to it, rather than one who had forced an entry through violence alone. The exact date within December of 1878 on which the murder occurred is not established in the sources available for this account, and is treated here as unconfirmed, the record preserving only the month and year. Rachel Samuel was beaten to death. The surviving record does not preserve a detailed clinical account of her injuries, and none should be supplied here beyond the essential fact that the attack was fatal and was carried out by means of a beating rather than by a blade or by strangulation. In addition to the assault itself, the perpetrator removed from the house, or from Rachel Samuel's person, several items of value. Her wedding ring was taken, a quantity of coins was taken, her boots were also taken, an item whose removal is recorded alongside the ring, and the coins without further explanation as to its significance, though the theft of footwear from a body or a household was not without precedent in period crime. Footwear representing a saleable item of practical value in a city where second-hand goods of every kind supported an active trade among those with limited means. The combination of a fatal beating and the removal of a specific, limited set of valuable items indicates a crime in which robbery was, at minimum, a significant component. Whatever additional motive may or may not have attached to it, the record available for this account does not establish who first discovered Rachel Samuel's body, nor the precise circumstances of that discovery, nor the hour at which it occurred. This is treated here as a gap in the surviving documentation rather than a fact to be supplied by inference. What can be said is that the discovery of her body led to the involvement of the police and the opening of a formal investigation into her death, an investigation that would, in time, focus its attention on the woman who had once served in her household. The investigation into the death of Rachel Samuel proceeded, as was standard practice for a case of this nature, in the London of 1878, with the dispatch of officers to the scene at Burton Crescent to examine the property and to begin the process of establishing what had occurred. The Metropolitan Police by this period maintained a detective department tasked with the investigation of serious crime within the Metropolitan District, and a case involving a violent death in a respectable residential crescent would have received the attention of officers experienced in such inquiries. The condition of the kitchen, the items found to be missing from the house, and the apparent absence of any sign of forced entry would have formed the initial basis of the inquiry, directing attention toward the question of who might have had knowledge of the house and access to it without arousing suspicion. It was in the course of this inquiry that Mary Donovan's prior connection to the household came to the attention of investigating officers. A woman who had served within a house possessed a familiarity with its layout, its habits, and its contents that was not shared by strangers, and the fact of her former employment there was sufficient to direct suspicion toward once the basic facts of the crime had been established. Officers made inquiries into her whereabouts and her circumstances following her departure from Rachel Samuel's service, gathering what information could be obtained from those who had known her or who could speak to her movements in the period surrounding the murder. This process of inquiry, standard in cases where a domestic connection to the victim was known, proceeded through the taking of statements from neighbours, tradespeople, and any other residents of Burton Crescent or the surrounding streets who might have observed unusual activity at or near the house in the relevant period. The taking of statements in a case of this kind followed an established procedure. Officers would call at the neighbouring houses along the Crescent, asking whether anything unusual had been seen or heard, whether any stranger had been observed entering or leaving the property, and whether the residents were aware of Rachel Samuel's recent habits or visitors. Tradespeople who called regularly at the house, such as those who delivered milk, coal, or provisions, would similarly have been asked what they recalled of their most recent calls, whether the household appeared as it always had, and whether Rachel Samuel or any other person had been seen about the property. The surviving record does not preserve the content of these statements, nor does it name the individuals from whom they were taken, and no such detail should be supplied here beyond the fact that this stage of the investigation was, by the standards of the period, thorough in its scope, even where its results were not. Attention converged upon Mary Donovan as the investigation proceeded. Her former position within the household placing her in a category of persons whose knowledge of Rachel Samuel's residence and possessions exceeded that of any casual acquaintance. She was traced, questioned, and in due course arrested in connection with the murder. The arrest of a suspect on the basis of prior domestic access was consistent with the investigative logic of the period, in which the search for an assailant in cases without an obvious external forced entry turned naturally toward those who had once possessed legitimate means of entering the property and who understood its contents well enough to know what might be taken and where it might be found. Nothing in the surviving record establishes a specific motive attributed to Mary Donovan by investigators, nor any statement or confession made by her, and none should be inferred beyond the bare fact of her arrest. Following her arrest, Mary Donovan was held and questioned by the police in the course of the ongoing investigation into Rachel Samuel's death. The examination of a suspect under these circumstances would have involved repeated questioning as to her movements in the period surrounding the murder, her whereabouts on the occasion in question, and any explanation she might offer for her connection to the missing items or to the scene of the crime. The investigating officers would have sought to establish whether her account of her movements could be corroborated by other witnesses, and whether any of the stolen property, the wedding ring, the coins, or the boots could be traced to her possession or to any transaction she might have conducted following the murder. The surviving record does not preserve the substance of her responses to this questioning, nor any detail of her demeanour or conduct while in custody. The investigation having proceeded through the identification of a suspect, the taking of statements, and the questioning of Mary Donovan herself, ultimately failed to produce evidence sufficient to sustain a prosecution. No physical evidence connecting her directly to the scene of the crime is recorded as having been recovered. None of the stolen items, so far as the surviving documentation indicates, were traced into her possession. No witness came forward whose testimony could place her at Burton Crescent on the occasion of the murder or establish her movements in a manner inconsistent with innocence. In the absence of such evidence, the case against her could not proceed to a formal charge, and she was in due course released from custody without trial. The release of Mary Donovan marked, in effect, the conclusion of the active investigation into the death of Rachel Samuel. No further suspect is recorded as having been identified, questioned, or arrested in connection with the case. The investigation, having exhausted the line of inquiry that her former employment in the household had opened, appears to have proceeded no further, the case remaining in the position it had reached at the point of her release. No coroner's name, no date of inquest, and no recorded verdict of a coroner's jury has been preserved in the sources available for this account, though the convening of an inquest would have been standard practice for any sudden and violent death within the metropolitan district in this period, conducted before a coroner and a jury drawn from the local area, tasked with determining the cause of death and, where possible, the circumstances surrounding it. Whatever the substance of that inquest may have been, its record does not survive in a form accessible to this account, and no detail of its proceedings should be supplied beyond the acknowledgement of the gap itself. The house at number 4, Burton Crescent, remained standing after the events of December 1878, its address continuing to appear in the ordinary records of the Crescent for some years afterward. The Crescent itself, however, would in time undergo a change that stands as the most durable trace of the case in the historical record. In 1884, a second murder occurred at Burton Crescent, unconnected in any documented respect to the killing of Rachel Samuel, but occurring elsewhere on the same crescent at number 12 within a span of 6 years, a coincidence of location that attached to the crescent a reputation for violent death that outlasted the memory of either individual case. By the early years of the 20th century, the name Burton Crescent had become sufficiently associated with these two killings that in 1908 the street was formally renamed. It became Cartwright Gardens, a name it retains, taken in honour of the 18th century political reformer John Cartwright, whose statue stands nearby in Burton Place. The renaming was undertaken in part, according to the local histories that record it, as a means of severing the street's identity from the notoriety the two murders had attached to it, an act of civic erasure carried out a generation after the crime it sought to leave behind. The renaming of Burton Crescent is the clearest surviving evidence of the impact the case had upon its immediate surroundings. No book, ballad or dramatic treatment devoted specifically to the murder of Rachel Samuel has been identified in the sources available for this account. The case did not enter the broader currency of published Victorian crime literature in the manner of the era's more widely reported killings, and no record survives of any contemporary published account beyond the brief newspaper notices that would have accompanied the discovery of the body, the arrest of Mary Donovan, and her subsequent release. What persisted was not the story of the crime itself, but the physical trace it left upon the street where it occurred, a trace that required the erasure of a name to accomplish. The Skinner's Company estate, upon which Burton Crescent had been constructed between 1809 and 1811, had been laid out according to a plan common to the developing districts of Georgian and Regency London, in which a landowning company or trust granted long leases to builders who erected uniform terraces of brick townhouses, their facades stuccoed or left in plain brick according to the fashion of the moment, their interiors arranged on the standard pattern of the period, a basement kitchen and service quarters, a ground floor given to reception rooms, and upper floors divided between bedrooms, and in the largest houses, further accommodation for servants beneath the roof. A house at Burton Crescent, by the standards of its construction, would have offered a resident of Rachel Samuel's means a degree of comfort and privacy considerably beyond that available to the great majority of London's population in 1878, a city in which overcrowding in the poorer districts to the east and south left many families sharing single rooms, while a widow of independent standing in Bloomsbury occupied a house of several floors, largely to herself, attended by no more than one or two servants at most. This disparity in circumstance was itself unremarkable within the social geography of the period, Bloomsbury having developed specifically as a district for households of exactly this description. Professional families, retired merchants, and widows and unmarried women of modest independent income who required neither the scale of a great townhouse in Mayfair nor the more precarious accommodation available further east. The presence of King's Cross and Euston stations within walking distance to the north had by the 1870s brought a degree of transient traffic and commercial activity to the streets surrounding the Crescent that had not been present at the time of its original construction, the railways having reshaped the character of the surrounding area over the preceding 3 decades. Yet Burton Crescent itself, set back from the main thoroughfares, retained the quieter, more settled character of its original design, its railings and porticoed doorways presenting an appearance of order and respectability to any passerby. Within a household of this kind, the relationship between an elderly widow and a servant, whether current or former, carried a particular weight. A servant engaged in such a house was typically responsible for the full range of domestic labour, rising before her employer to lay and light the kitchen fire, fetching water and coal, preparing meals, cleaning the rooms, answering the door, and very often sleeping within the house itself, in a room set aside beneath the roof or adjoining the kitchen. This arrangement placed the servant in close and continuous proximity to her employer's daily life, her possessions, and her routines, an intimacy of knowledge that, in the great majority of cases, produced nothing more than the ordinary functioning of a household, but which, in cases such as this one, became the basis on which suspicion was later directed. The precise date on which Mary Donovan's service in the house had ended, and the terms on which it had concluded, were not preserved in any surviving account, leaving open the question of how much time had elapsed between her departure and the events of December 1878, and whether she retained, at the time of the murder, any means of entry to the house that her former position might once have afforded her. The coincidence by which a second violent death occurred at the same address 6 years later, in 1884, was sufficiently striking to two separate generations of Bloomsbury residents that it became, in time, the defining association carried by the name Burton Crescent, an association strong enough that it outlasted both individual investigations and both individual victims. Local vestry records and later histories of the street preserve the renaming of 1908 as a deliberate act undertaken by residents and local authorities together, motivated by the accumulated weight of a reputation that no single explanation, whether the age of the buildings, the character of later tenants, or simple misfortune, could otherwise account for. The choice of the name Cartwright Gardens, honouring a reformer associated with the district rather than any figure connected to either killing, reflected an intention to replace the Crescent's association with violence with one drawn instead from a more distant and more comfortable civic memory. The renumbering that accompanied the change of name in 1908 required the alteration of every address, along the Crescent, number 4 among them, the postal and municipal authorities issuing new designations under the name Cartwright Gardens, that replaced, house by house, the sequence of numbers that had stood since the street's construction nearly a century before. Tradesmen's directories, electoral rolls, and rate books of the period reflect this transition in the years immediately surrounding 1908, the old name persisting in some records for a time, even as the new one came into official use, a slow administrative changeover typical of such renamings, in which correspondence, deliveries, and legal documents continued for some years to carry the earlier designation before the newer name became fully established in ordinary usage. The physical fabric of the Crescent itself, the brick terraces, the iron railings, the portico doorways remained unaltered by the change, so that a resident of 1910 walking the length of Cartwright Gardens would have seen precisely the streetscape that a resident of 1878 had known, the alteration existing entirely in name rather than in stone. The gardens at the centre of the Crescent, laid out as communal ground for the use of residents in the original 1809 design, continued through this period to serve their original function, a strip of trees and lawn enclosed within railings, accessible by key to those households holding a share in its upkeep, a common feature of London's Georgian and Regency squares, and crescents that provided a measure of private open space within an increasingly dense city. Such gardens formed part of the ordinary rhythm of life for residents of Rachel Samuel's class and generation, a place for a short walk, for children of neighbouring households to be taken for air, for the kind of unremarkable daily activity that left no trace in any surviving record, but that constituted the texture of life along the Crescent in the years before and after 1878. Nothing in the documentation available establishes whether Rachel Samuel herself made use of this garden, held a key to it, or was known to any of the households that shared its upkeep, and no such detail should be assumed. The absence of a resolution to the case, the fact that no individual was ever convicted of Rachel Samuel's murder, placed it within a category of Victorian domestic crime that was, in the London of the period, neither unusual nor widely remarked upon at the time. Investigations of this kind, particularly those concerning victims outside the small number of cases that attracted sustained press interest, frequently concluded in precisely this manner, with a single suspect identified, examined, and released for want of evidence, and with no further inquiry pursued once that line had been exhausted. The Metropolitan Police of 1878 handled a considerable volume of such cases annually, and the resources devoted to any individual investigation were necessarily finite, weighed against the demands of the many other matters occupying the detective department in the same period. The case of Rachel Samuel, lacking the scale of public attention that might have sustained a longer or more extensive inquiry, appears to have received the standard measure of investigative effort available under these circumstances, an effort that proved in the end insufficient to identify with certainty the person responsible for her death. Mary Donovan's passage through the machinery of the law, so far as it can be reconstructed from the standard procedure of the period, would have begun not with a formal indictment but with an appearance before a metropolitan police magistrate, the ordinary first stage through which any person arrested on suspicion of a serious crime in London was required to pass. Such a hearing, conducted at one of the metropolitan police courts serving the Bloomsbury district, would have been brief, the magistrate hearing a summary of the evidence gathered by the investigating officers and determining whether sufficient grounds existed to remand the accused in custody for further inquiry or to discharge her outright. It was standard practice in cases of this kind for a magistrate to grant an initial remand where the police could show a reasonable basis for continued suspicion, even short of evidence sufficient for trial, in order to allow further investigation to proceed while the suspect remained in custody. A remand of this nature would have placed Mary Donovan in one of the houses of detention maintained for those awaiting further hearings, most commonly Clerkenwell or a similar institution serving prisoners held on remand within the metropolitan district. Rather than in a convict prison, the distinction between remand custody and post-conviction imprisonment being maintained throughout the process. She would, under ordinary practice, have been brought back before the magistrates at intervals, the police reporting on the progress of their inquiries and requesting either a further remand or, where the evidence had failed to develop, informing the court that no further evidence could be offered. It was at such a hearing, in the ordinary course of these proceedings, that a magistrate confronted with a case in which the police could point to prior domestic connection, but nothing further, no witness, no recovered property, no admission, would discharge the accused, the law requiring more than suspicion, however reasonably founded, to hold a person for trial. This is the process by which Mary Donovan is understood to have been released, the record establishing the fact of her discharge without preserving the transcript of the hearing at which it occurred. The case of Rachel Samuel belongs to a broader pattern documented among the unsolved domestic murders of Victorian London, a pattern in which elderly women living alone, often widows of some independent means, were killed within their own homes under circumstances suggesting an assailant with prior knowledge of the household, rather than a stranger who had forced entry by violence. Such cases posed a particular difficulty for the investigative methods available to the police of the period, methods that depended heavily upon witness testimony, the tracing of stolen property through the pawn shops and second-hand dealers who formed a significant part of London's informal economy, and the identification of suspects through networks of prior acquaintance in the absence of the forensic techniques that would, in later decades, transform the investigation of violent crime. A case in which the assailant left no witness, disposed of, or retained the stolen items without detection, and could not be placed at the scene by any surviving account was, under these methods, extremely difficult to resolve, regardless of the diligence with which the initial inquiry was pursued. Later compilations devoted to the unsolved murders of Victorian London have grouped the case of Rachel Samuel among a small number of comparable killings from the same decade, cases sharing the common features of an elderly or vulnerable victim, a domestic setting, the theft of readily portable valuables, and the identification of a servant or former servant as the principal suspect without sufficient evidence to secure a conviction. These compilations, produced well after the events themselves, serve chiefly to preserve the memory of cases that received little sustained attention in their own time, drawing together the scattered newspaper notices and court records that might otherwise have been lost entirely to the historical record. It is through sources of this kind, rather than through any dedicated contemporary account, that the case of Rachel Samuel has continued to be documented into the present day, her name and the essential facts of her death preserved within a wider survey of a category of crime that London's Victorian police force confronted with only partial success throughout the second half of the 19th century. The trade in second-hand goods through which stolen property most commonly passed in the London of 1878 operated through a dense network of pawnbrokers, marine store dealers, and general second-hand shops distributed throughout the city, institutions to which the police maintained routine communication in cases involving theft, providing descriptions of missing items in the hope that a broker might recognise property offered for pledge or sale as matching a description already circulated. A wedding ring, being a plain gold band without the kind of distinguishing engraving that might allow certain identification, presented particular difficulty in this respect, such an item being readily melted down or sold without any feature that would connect it definitively to a specific theft. Coins, being fungible by their very nature, offered no means of tracing at all once they had entered general circulation. Boots, though more distinctive in principle, were also among the most commonly pawned items of clothing in Victorian London, a trade in second-hand footwear supporting a significant portion of the city's poorer population, and a single pair offered at any one of the hundreds of pawn shops operating across the metropolis would have presented very little basis for identification unless a broker happened to recall the specific transaction and connect it, unprompted, to the circulated description of the Burton Crescent theft. It was against this backdrop that the failure to recover any of the stolen items should be understood, not as an anomaly in the investigation, but as a common outcome in cases of this kind, the ordinary channels through which the police sought to trace stolen property offering only a modest prospect of success. Even under the most diligent pursuit, the absence of any recovered item, combined with the absence of any witness placing Mary Donovan at the scene, left the investigating officers with nothing beyond the fact of her prior service in the household, a fact that, however suggestive, could not by itself satisfy the evidentiary standard required to bring a charge before the courts. The gap between suspicion and proof, a gap that runs through a great many of the unsolved cases of the period, is nowhere more starkly illustrated than in the case of Rachel Samuel, where a plausible line of inquiry was pursued to its full extent and yielded, in the end, nothing that the law could act upon. The domestic service that had once connected Mary Donovan to the household at Burton Crescent was, in 1878, among the largest single categories of female employment in London, a trade engaging a substantial proportion of working women across the city, from young girls entering their first situations as scullery maids to older women who had spent decades moving between households in positions of increasing responsibility. The wages, conditions, and security of such positions varied enormously according to the size and standing of the household. A servant in a large establishment with a full staff enjoying a very different existence from one who served alone in a modest house, responsible for the entirety of its domestic labour without the support of a housekeeper, a cook, or additional maids to share the burden. A household such as Rachel Samuel's, a widow living alone, would most plausibly have required only a single general servant, a position that combined the duties of cook, housemaid, and general attendant within one individual, a role demanding long hours and considerable physical labour for wages that, even by the standards of the period, remained modest. The transition out of such a position, whether through dismissal, resignation, or the natural conclusion of a period of engagement, left a servant to seek a new situation, a process typically pursued through registry offices, newspaper advertisements, or personal recommendation from a previous employer. The character reference applied by a former mistress carrying substantial weight in a servant's prospects for future employment. Whether Mary Donovan had, by December of 1878, secured a new position, remained without employment, or existed in some intermediate state of seeking work is not recorded in any source available for this account, and the question of her circumstances in the period following her departure from Rachel Samuel's household must be left, like so much else in this case, as a gap in the surviving record rather than a fact to be supplied. The registry offices, through which servants sought new positions, in this period operated as a formal marketplace of character and reference, a servant registering her name, her experience, and the nature of the position she sought, while prospective employers called upon the same offices seeking staff of a particular kind: kitchen maids, general servants, cooks, or ladies' maids, according to the requirements of their household. A servant without a satisfactory character reference from her most recent employer found her prospects considerably diminished, the reference functioning as the primary mechanism by which the domestic labour market of Victorian London regulated itself in the absence of any formal system of credentials or training certification. A mistress who dismissed a servant for theft, dishonesty, or misconduct would ordinarily refuse to supply a character reference at all, or would supply one carefully worded to signal reservation without stating the cause outright, a practice well understood among both servants and employers of the period. Whether Rachel Samuel had, at the conclusion of Mary Donovan's service, supplied such a reference, refused one, or offered qualified praise is not preserved in any surviving account, and the absence of this detail leaves unanswered the question of whether the two women parted on terms that could later have been read, however speculatively, as a source of resentment. The house at number 4, Burton Crescent, in common with others of its type and period, would have been arranged according to a standard plan familiar throughout the terraces of Bloomsbury and the surrounding districts. A half flight of steps descended from the pavement to the basement area, where the kitchen door opened onto the working quarters of the house, while a further flight rose to the pillared front entrance used by the household and its visitors. Within the kitchen itself, the dominant feature would have been the cooking range, an iron construction set into the chimney breast, fired by coal and requiring daily attention to the raking of ash and the laying of fresh fuel, its flues and ovens providing both the means of cooking and a significant source of heat for the lower floors of the house. A dresser holding crockery, a deal table scrubbed white with repeated cleaning, and shelves for the storage of provisions would have completed the ordinary furnishing of such a room, along with, in a house of this size, a system of bells connected by wire to pulls in the rooms above, allowing a resident on the upper floors to summon a servant to the kitchen level without the need to call out or descend the stairs herself. Such a bell system, standard in houses of this class by the middle of the 19th century, created within the household a particular pattern of communication and dependency. The servant positioned below stairs and responsible for responding to summons from above, her presence in the kitchen an almost constant feature of the household's daily rhythm. In a house occupied by a single elderly resident with, at most, one servant in attendance, the kitchen would have served not only as a place of labour, but very often as the servant's principal living space during the working day, a room in which she might also take her own meals and pass what free time her duties allowed. The intimacy of this arrangement, two women, mistress and servant, moving through the same limited domestic space day after day, each dependent upon the other in different ways for the functioning of the household, forms the backdrop against which any relationship between Rachel Samuel and Mary Donovan, whatever its particular character, must be understood. The examination of a body discovered under violent circumstances in the London of 1898 followed an established sequence, beginning with the attendance of a police surgeon summoned to the scene, a medical practitioner engaged by the police for the specific purpose of examining bodies found under suspicious circumstances within a given division. Such a surgeon would have attended at Burton Crescent to confirm that death had occurred, to form an initial impression of the cause and probable timing of death based upon the condition of the body, and to advise the investigating officers on any matter bearing upon the immediate conduct of the inquiry before a fuller post-mortem examination was conducted, typically at a mortuary rather than at the scene itself, to establish with greater precision the cause of death for the purposes of the coroner's inquest. The name of the surgeon who attended in this case and the mortuary to which Rachel Samuel's body would have been removed are not preserved in any source available for this account. The coroner's inquest, convened as a matter of standing legal requirement for any sudden or violent death within the jurisdiction, would have proceeded according to a fixed and familiar pattern throughout London in this period. A coroner, an official distinct from the police and the judiciary, presided over a jury drawn from among the local ratepayers, ordinarily numbering upward of 12 men, tradesmen and householders of the district called upon to serve in this capacity as a civic obligation. The jury would be shown the body, a practice retained in this period as a formal requirement of the inquest process, before hearing testimony from those able to speak to the circumstances of the death, the medical evidence offered by the examining surgeon, and any statement the police were prepared to offer regarding the state of the investigation. At the conclusion of the evidence, the jury would retire to consider a verdict. The available findings in a case of unexplained violent death ranging from willful murder, naming a specific individual where the evidence supported it, to willful murder against a person or persons unknown, where the evidence established the fact and manner of the killing without identifying its author. No record of the specific verdict returned in the case of Rachel Samuel survives in the sources available for this account, though a finding consistent with murder by a person or persons unknown would have been the ordinary outcome in a case where, as here, no individual had by that stage been charged. The jury convened for such an inquest, drawn from the immediate neighbourhood of the crime, would very often have included men with some personal knowledge of the deceased or of the street on which she had lived, a feature of the coroner's system that lent to these proceedings a distinctly local character, quite unlike the more formal and distant atmosphere of a criminal trial conducted before judge and jury at the assizes. A Bloomsbury tradesman called to serve on such a jury might himself have passed number 4 Burton Crescent on his daily rounds for years without particular incident, his summons to the inquest room representing his only formal engagement with a case that had, until that point, existed for him only as a matter of local report and rumour passed along the Crescent and its neighbouring streets. The inquest itself would ordinarily have been convened at a public house or similar establishment in the immediate vicinity of Burton Crescent, this being the standard practice throughout London at the time, in the absence of purpose-built coroners' courts in most districts. A room set aside above, or adjoining the bar for the formal business of the jury and its witnesses. Such a setting, however incongruous it might appear by later standards, was entirely unremarkable to those who attended, the public house serving as one of the few spaces in a residential district large enough and available enough to accommodate a coroner, his officer, a jury of 12 or more men, and whatever witnesses had been summoned to give evidence. The proceedings would have opened with the coroner's officer reading the particulars of the case, followed by the formal viewing of the body. Before testimony was taken in turn, each witness sworn and examined by the coroner directly. The more adversarial procedure of a criminal trial, with counsel for prosecution and defence having no place within the inquest process itself. Bloomsbury, in 1878, fell within the area of responsibility of one of the Metropolitan Police's numbered divisions, its streets patrolled by uniformed constables, walking fixed beats through the day and night, each beat covering a defined circuit of streets that a constable was expected to traverse at regular intervals, his passage timed so that no street within his beat went unobserved for more than a set number of minutes at any hour. Burton Crescent, as a residential street of some standing, would have fallen within such a beat, its constable a familiar figure to residents. Known by sight if not always by name, his passage past the Crescent's railings a routine feature of the street's daily and nightly rhythm. The gas lamps that lit Burton Crescent by this date were tended by a lamplighter who made his rounds at dusk and again, before dawn, lighting and extinguishing the individual lamps along his route by means of a long pole, a service provided under contract to the parish, and forming, together with the constable's beat, one of the two principal forms of public order and illumination that govern the experience of the street after nightfall. A constable on such a beat, passing Burton Crescent in the course of an ordinary night in December of 1878, would have had no particular reason to regard number 4 as different from any other house along the terrace, its front unlit at that hour, save perhaps for a glimmer at a curtained window, its area, railings and steps indistinguishable from those of its neighbours. The murder of Rachel Samuel, occurring as it did within the house itself rather than upon the street, would have left no sign visible to a constable passing on his beat. The crime committed and concluded within walls that gave no outward indication of what had occurred inside, a circumstance common to domestic murders of this kind, and one that placed the burden of discovery not upon the routine vigilance of street patrol, but upon whoever within the household or its immediate circle first had cause to enter the house and find that its occupant did not answer. The parish in which Burton Crescent stood, St Pancras, was by 1878 one of the more populous parishes of the metropolitan district. Its vestry responsible for a wide range of local administrative functions, including the paving, lighting and cleansing of its streets, functions that, in the case of a respectable residential crescent, such as Burton Crescent, would have been maintained to a standard consistent with the character of its residents. Rates levied upon householders funded these services, a system through which a woman such as Rachel Samuel, as the occupier of a substantial house, would have contributed directly to the upkeep of the very street on which she was killed, her name appearing in the ordinary course of parish administration upon the rate books maintained for this purpose, one of the few forms of documentary trace that a woman of her circumstances would routinely have left behind in the official record of her time, quite apart from the notoriety that the manner of her death would later attach to her name. The case file was closed without resolution. No suspect was charged. The record remained as it stood. That is where the record of the second case comes to its close. What remains is a third account, older than the other two by several decades, set not in a market town or a genteel city square, but along the theatre district of South London, in the earliest years of the young Queen's reign. It concerns a woman who supported herself by her own labour, in a trade the record does not disguise and does not dwell upon, and whose death would in time find its way, by a path no court ever traced, into one of the most widely read novels of the century. The case of Eliza Grimwood begins in Lambeth, on the south bank of the River Thames, in the spring of 1838. Lambeth, in 1838, was a densely settled parish directly across the river from the city of Westminster, connected to it by Waterloo Bridge, and it had grown rapidly in the preceding decades as London's population expanded southward. The parish combined manufacturing premises, close-packed residential terraces, and a concentration of theatres and places of public entertainment along and near Waterloo Road, which by the 1830s had become one of the principal entertainment thoroughfares south of the river. Gaslighting had been introduced to many of London's main streets over the previous 2 decades, and Waterloo Road, with its playhouses and taverns, was among the better lit and more heavily trafficked routes in the parish after nightfall. The Metropolitan Police, established in 1829, was by 1838 a young institution not yet a decade old, organised into numbered divisions that patrolled fixed beats, and it had at this date no dedicated detective branch. Investigation of serious crime relied on divisional officers, parish constables, and the ordinary processes of inquiry available to a coroner's court, supplemented where necessary by Bow Street runners and by the Metropolitan Force's own inspectors. Wellington Terrace stood in this setting, a row of residential houses on or near Waterloo Road, within easy walking distance of the theatres whose evening performances drew crowds from across the river and from within Lambeth itself. The terrace housed a mixture of working residents, tradesmen, and, as was common in streets adjoining a theatre district in this period, women who supported themselves independently in the absence of other reliable means of income available to unmarried women of the labouring and lower middle classes. The record identifies Eliza Grimwood as a resident of Wellington Terrace who supported herself in this manner, working under her own name rather than any alias. Contemporary testimony given at the inquest into her death described her as a woman of sober habits and stated that she had saved a degree of money from her earnings, a detail entered into the formal record of the case rather than a later embellishment. Eliza Grimwood was approximately 25 years of age at the time of her death. Contemporary inquest testimony described her as about 25, and later summaries of the case have given her age as 26. The surviving record does not resolve the discrepancy with precision, and this account treats her as having been in her mid-20s. The available record does not establish her birthplace, her parentage, or the circumstances of her early life prior to her residence at Wellington Terrace. A later regional newspaper account has been read by some as suggesting a possible origin in Suffolk, in the vicinity of Ipswich and the village of Stonham Aspel, but this connection is not established with confidence in the sources examined for this account, and it is presented here, if at all, only as an unverified theory rather than a documented fact of her early life. What the record does establish, with reasonable consistency across contemporary and later sources, concerns the years immediately preceding her death rather than her childhood or origins. Eliza Grimwood had, for close to a decade, shared her residence with a man named William Hubbard. Hubbard was her first cousin. He was a married man, though he had not resided with his own wife for a period of approximately 12 years prior to the events of 1838. For most or all of the years he lived with Eliza Grimwood, he was, at least in part, supported by her earnings, a fact that would assume considerable significance once the investigation into her death began. The nature of their arrangement, as it is described in the sources gathered for this account, was that of a long-term domestic partnership between cousins, conducted outside the bounds of Hubbard's existing marriage, and sustained in material terms chiefly by Eliza Grimwood's own income. The record offers little further detail of her daily life beyond these facts. She is not described in the surviving testimony as a woman without means or without discipline in the management of what she earned. The description of her as being of sober habits and as having saved money stands in the available record as a corrective to any assumption that her manner of living was one of disorder. Beyond this, the sources examined do not establish further particulars of her habits, her associations, or her reputation among her neighbours at Wellington Terrace, and this account does not supply such particulars where the record is silent. What follows begins in Lambeth in the spring of 1838. The circumstances immediately preceding Eliza Grimwood's death centre on the evening of the 26th of May, 1838, and on two men whose presence in her life that evening the surviving record records with some clarity, though neither man's precise role in what followed was ever conclusively established. The first of these was William Hubbard, already described, whose residence with her at Wellington Terrace continued up to the time of her death. The second was a man who accompanied her home from the theatre on the night in question, a man who does not appear to have been previously known to the household in any way the record preserves, and whose identity was never established either at the time or subsequently. On the evening of the 26th of May, Eliza Grimwood attended a theatre, one of the several playhouses that drew evening audiences to the Waterloo Road district. The record does not specify which theatre, nor does it name any companion with whom she attended the performance itself. What the record does establish is that following the performance, she returned to her residence at Wellington Terrace in the company of a man, a client in the ordinary course of her occupation, whom contemporary accounts describe as foreign in appearance. This description, drawn from contemporary testimony, is the only characterization of the man that survives. His nationality, his name, and his subsequent movements after leaving her company were never established by the investigation that followed. William Hubbard's own whereabouts on the evening of the 26th of May and the precise arrangement by which Eliza Grimwood's residence accommodated both a long-term domestic partner and a client received in the course of her occupation are not detailed with precision in the surviving record. What is established is that Hubbard was residing at Wellington Terrace at the time, that he was present in the household in the periods surrounding the killing, and that his relationship to Eliza Grimwood, both personal and financial, placed him in a position that the investigation would treat as one of immediate and central interest once her death became known. The unnamed theatre companion is the last person the surviving record places in Eliza Grimwood's company before her death. No account describes the two of them quarrelling, nor does any surviving testimony describe the manner of the man's departure from the house, whether before or after the fatal injury was inflicted. The record simply establishes his presence that evening and his subsequent permanent disappearance from any documentary trace. This absence of further detail is not a gap introduced by the passage of time alone. It appears to have been a gap in the investigation itself, one that contemporary and later writers on the case have treated as a significant unresolved element of the record. As a brief procedural summary, the circumstances leading to Eliza Grimwood's death centre on two men present in her life in its final hours. One, a long-term domestic partner of a decade's standing who depended in part on her earnings, and one, a client whose identity was never established. Neither man's account of the evening survives in the record in any detail beyond these bare facts. The investigation that followed her death would treat William Hubbard as its principal object of suspicion, owing to his domestic and financial connection to her, while the unidentified companion remained throughout, a figure the inquiry could describe but never locate. William Hubbard's position in the household, and in the subsequent investigation, warrants further examination on its own terms. He was, as established, Eliza Grimwood's first cousin, a fact that placed their relationship within a family connection rather than an entirely unrelated domestic arrangement. He had married at some point prior to the events of 1838, though the record does not supply the date of that marriage, and he had ceased to reside with his wife, for a period the sources place at approximately 12 years. During this period of separation from his wife, he had come to reside with Eliza Grimwood, an arrangement that endured for close to 10 years by the time of her death in 1838. The financial dimension of this arrangement is recorded with some consistency across the sources examined. Hubbard was, at least in part, supported by Eliza Grimwood's earnings during the period they lived together. This detail does not appear in the record as an incidental fact. It forms part of the basis on which the subsequent investigation directed its earliest and most sustained suspicion toward him, since a man financially dependent upon a woman with whom he shared a household stood, in the reasoning available to investigators of the period, as the person with the clearest material interest in the household's affairs and the readiest opportunity to have been present at the time of her death. The surviving record does not describe Hubbard's character, temperament, or reputation among neighbours in any detail beyond the bare facts of his relationship to Eliza Grimwood and his financial position within the household. Later assessments of the case, produced well after the events of 1838, have suggested that Hubbard lacked the capacity to plan and carry out a killing of the kind that occurred, a killing later writers have characterised as one demanding a degree of premeditation and composure. This assessment belongs to modern historical analysis of the case rather than to the contemporary investigative record, and it is presented here as such, a retrospective judgment rather than a documented fact established at the time. The investigation that followed her death did not, in the end, produce sufficient evidence to sustain a charge against William Hubbard, and no physical evidence was ever found connecting him to the killing. He was questioned, held for a period as the case against him was considered, and ultimately released without prosecution. Following his release, Hubbard emigrated to the United States. The record does not establish the precise date of his departure, only that it followed the investigation into Eliza Grimwood's death, and no further trace of him survives in the sources gathered for this account. He was, so far as the documentary record shows, never heard from again. The killing itself occurred during the night of the 26th of May, 1838, at Eliza Grimwood's residence at Wellington Terrace, following her return from the theatre in the company of the unidentified man already described. The precise hour of the killing is not established in the surviving record. What is established is that her throat was cut and that she sustained additional and severe injury to her body beyond the wound to the throat. The available sources do not permit, and this account does not attempt, a more particular description of the injuries than this. It is sufficient to record that the injuries were severe, that they were rapidly fatal, and that they were of a character sufficient to leave no doubt, once the body was discovered, that a killing rather than an accident or a natural death had occurred. No account survives of any outcry heard by neighbours at Wellington Terrace during the night, nor of any disturbance reported to the parish constables or to the Metropolitan Police Division, responsible for that beat before the following morning. The theatre district around Waterloo Road was, on an ordinary evening, a place of considerable noise and movement well past the hour at which the playhouse is emptied, as audiences dispersed on foot and by cab, and made their way home along the gaslit thoroughfare, and it is possible that whatever sounds accompanied the killing were lost within this ordinary evening traffic. The record, in any case, preserves no witness to the killing itself, and none who came forward to describe having heard it as it occurred. Eliza Grimwood's body was discovered at her residence on the morning following the killing. The discovery is recorded as having been made at Wellington Terrace itself, in the course of the ordinary routine of the household, though the surviving sources do not name the individual who made the discovery or describe in detail the manner in which the body was found. What the record establishes with confidence is that by the morning of the 27th of May, it was known within the household, and rapidly thereafter within the neighbourhood, that Eliza Grimwood had been killed during the night. And that word of the killing spread quickly through Lambeth and across the river into the wider metropolis, owing both to the violent character of the crime and to the fact that a woman living independently in a residence of this kind had been killed within her own home. The news of Eliza Grimwood's death moved rapidly through the surrounding parish once the discovery had been made, carried first by those in the immediate vicinity of Wellington Terrace, and then within a matter of hours into the columns of the Metropolitan Press. London in 1838 supported a large number of daily and weekly newspapers, several of which maintained a particular appetite for reports of violent crime, and a killing of this character, involving a woman established in the neighbourhood and occurring within the theatre district itself, was well suited to the kind of sustained press attention that a killing in a less populous or less visible part of the city might not have received. The parish constables and the divisional officers of the Metropolitan Police were among the first to be summoned to Wellington Terrace once the body had been found, and it was upon their initial examination of the scene that the earliest steps of what would become a prolonged and, in the assessment of later writers, a convoluted investigation were taken. The investigation into Eliza Grimwood's death was formally opened in the days immediately following the discovery of her body. Officers attached to the Lambeth Division of the Metropolitan Police, together with such parish constables as were available, undertook the initial work of securing the residence at Wellington Terrace and of establishing who had been present in the household in the period surrounding the killing. This was, as already noted, an investigation conducted 9 years after the founding of the Metropolitan Force and well before the establishment of any dedicated detective branch within it, a fact that shaped the methods available to those responsible for the inquiry. Investigators of this period relied chiefly on the taking of statements from those known to have had contact with the victim, on such physical observations as could be made at the scene itself, and on the pursuit of any information volunteered by members of the public, rather than on the specialised techniques that a later generation of detectives would bring to a case of this kind. William Hubbard's presence in the household and his long domestic and financial connection to Eliza Grimwood made him the earliest and most sustained object of the investigation's attention. He was questioned at length regarding his movements on the night of the 26th of May, regarding the state of his relationship with Eliza Grimwood in the period immediately preceding her death, and regarding his knowledge of her financial circumstances and of any money she was known to have saved from her earnings. The officers conducting the inquiry appear to have proceeded on the reasoning common to investigations of this period, that a man sharing a household with the victim and dependent in part upon her income stood as the person with both the opportunity and potentially the motive to have been responsible for her death. The investigation also directed attention toward establishing the identity of the man who had accompanied Eliza Grimwood home from the theatre on the night of her death. Inquiries were made, so far as the record allows this to be reconstructed, among those who might have observed her in the theatre or in its vicinity that evening, and among residents of Wellington Terrace and the surrounding streets who might have seen her return home in the company of this man. These inquiries did not succeed in establishing his identity, his nationality, or his subsequent movements after leaving the vicinity of Wellington Terrace, and this line of the investigation appears, on the evidence of the surviving record, to have reached no resolution. No physical evidence was recovered during the course of the investigation that connected William Hubbard, or any other identified individual, to the infliction of Eliza Grimwood's injuries. Statements were taken from him on more than one occasion as the inquiry proceeded, and he was, for a period, held in connection with the case, while the evidence against him was weighed by those responsible for the investigation. The absence of any physical evidence directly implicating him, combined with the difficulty of establishing a clear account of his movements that either confirmed or excluded his presence at the moment of the killing, left the investigation in a position it was never able to resolve. A post-mortem examination of Eliza Grimwood's body was conducted in the days following her death, in keeping with the ordinary procedure required in cases of sudden and violent death within the metropolis. The surviving record does not name the physician who conducted this examination, nor does it preserve the physician's report in the detail that survives for some cases of the period. What the record does establish is that the examination confirmed the cause of death to have been the injuries inflicted upon her, that these injuries were determined to have been rapidly fatal, and that the physician's findings were communicated to the coroner in preparation for the inquest that followed. The examination did not, so far as the surviving sources indicate, uncover any additional physical evidence bearing on the identity of the person responsible for her death. A coroner's inquest into the death of Eliza Grimwood was convened in accordance with the standing legal requirement that any sudden or violent death within the jurisdiction be examined by a coroner sitting with a jury. The surviving record does not preserve the name of the coroner who presided, nor the precise date on which the inquest was held, though it is established to have taken place within a short interval following her death, as was customary practice. The jury heard testimony concerning the discovery of the body, the findings of the post-mortem examination, and the circumstances of the household at Wellington Terrace, including testimony describing Eliza Grimwood as a woman of sober habits who had saved money from her earnings. Testimony was also given at the inquest touching upon William Hubbard's residence in the household and his financial dependence upon Eliza Grimwood, and touching upon her having attended the theatre on the evening of her death and having returned home in the company of an unidentified man. The jury was thus presented with the same essential facts that had occupied the police investigation, without the benefit of any additional evidence capable of resolving the question of responsibility. Having heard this testimony, and having been presented with no evidence sufficient to name a particular individual as responsible for the killing, the jury returned a verdict of willful murder against some person or persons unknown. This verdict, formally entered into the coroner's record, established that a killing had occurred and that the law recognised it as murder, while explicitly declining to attach responsibility to any named individual. The return of this verdict marked the formal conclusion of the coroner's proceedings, though it did not mark the end of public interest in the case. In the weeks that followed the inquest, the metropolitan press continued to report on the killing at some length, and it was during this period that speculation regarding the identity of the person responsible for Eliza Grimwood's death extended well beyond the two men the investigation itself had considered. Certain contemporary newspaper accounts advanced theories reaching considerably further than the evidence available to the coroner's jury, including, in at least one instance, speculation naming a figure of high social rank as a possible suspect. No evidence was ever produced in support of such speculation, and it did not form part of the coroner's proceedings or of the police investigation as those are documented in the surviving record. It is preserved here only as an illustration of the degree of public fascination the case provoked, and not as a credible line of inquiry. No individual was ever charged with the murder of Eliza Grimwood, and consequently no trial was held. The coroner's verdict of willful murder against some person or persons unknown stood as the final formal determination reached by any legal proceeding in the case. William Hubbard, having been questioned at length and having been held for a period while the evidence against him was considered, was released without charge, the investigation having failed to produce evidence sufficient to sustain a prosecution against him. The unidentified man who had accompanied Eliza Grimwood home from the theatre on the night of her death was never traced, and no further legal proceeding of any kind followed the conclusion of the coroner's inquest. As a brief procedural summary, the case of Eliza Grimwood concluded, so far as the formal legal record is concerned, with the coroner's verdict alone. No arrest beyond the initial questioning of William Hubbard was made to result in a charge, no trial was convened, and no sentence was ever passed, because no individual was ever brought before a court in connection with her death. The investigation conducted in the earliest years of the Metropolitan Police's existence, and without the benefit of a dedicated detective branch, exhausted the two lines of inquiry available to it, the domestic partner and the unidentified client, without resolving either into a formal charge. Following the conclusion of the coroner's inquest, the case of Eliza Grimwood remained a subject of considerable interest within the metropolitan press for some weeks, and its fame extended beyond the ordinary run of unsolved killings, owing in part to the manner in which the case became attached in the years immediately following to the work of a novelist, then in the early stages of a considerable career. Charles Dickens was, in 1838, in the course of the serial publication of a novel titled Oliver Twist, a work then appearing in monthly instalments and already attracting wide public attention. The killing of Nancy, a character within that novel, has long been noted by students of Dickens's work as bearing a marked resemblance to the killing of Eliza Grimwood, both in its violence and in the domestic circumstances surrounding it, and the two events unfolded within the same span of months. The novel's composition proceeding in close proximity to the public reporting of the Wellington Terrace killing. This connection between the two is not preserved in any statement by Dickens himself acknowledging the case as a direct source, so far as the sources gathered for this account establish, and it rests instead on the observations of later students of his work, who have noted the closeness in time between the killing of Eliza Grimwood and Dickens's composition of the chapters in which Nancy meets her death. It is on the strength of this observed proximity, rather than on any documented statement of intention, that the case of Eliza Grimwood has come to be associated with one of the best-known scenes of violence in Victorian English fiction. The connection has been examined at length in later historical writing on the case, most notably in a modern book-length study devoted to the killing, which situates the Wellington Terrace case within the broader currents of press interest in violent crime that characterised London in the years surrounding Victoria's accession to the throne. That same modern study has additionally proposed as an argument advanced by its author, rather than as an established finding of the contemporary record, that the killing of Eliza Grimwood may be understood as one of a small number of related killings carried out within the same district over a period of years, a theory linking her death to those of several other women, whose killings likewise went unresolved. This proposition belongs to modern historical argument rather than to the documentary record of 1838, and the coroner's jury, which examined Eliza Grimwood's death, considered her case entirely on its own terms, without reference to any other killing, returning its verdict of willful murder against a person or persons unknown solely upon the evidence placed before it concerning her own death. The years following Eliza Grimwood's death saw the Waterloo Road district continue much as it had before, a thoroughfare of theatres and taverns and residential terraces situated within a rapidly growing parish on the south bank of the river, and the surviving record does not indicate that her death produced any change in the policing of the district or in the practices of the Metropolitan Force more broadly. The case belongs, in the assessment of later writers, among the earlier instances of a kind of sustained public fascination with unresolved London killings that would recur across the remainder of the 19th century, its most famous later expression arising exactly half a century afterward in a series of killings within a different part of the East End. Eliza Grimwood's case preceded that later notoriety by 50 years, arising instead within the ordinary life of a theatre district still gaslit and still patrolled by a police force less than a decade into its existence, and it has been remembered since chiefly through the record the coroner's jury left behind and through its long association with a novel that was, at the time of her death, still being written. The Waterloo Road of 1838 stood within a stretch of Lambeth that had been transformed within living memory by the construction of the bridge from which it took its name, opened some 2 decades earlier and drawing both traffic and enterprise southward from the city and Westminster into a parish that had previously been considerably more rural in character. The road itself ran from the bridge approach down toward the Surrey Theatre and the smaller playhouses and places of entertainment clustered in its vicinity, and its pavements on any evening when a performance let out would fill with playgoers making their way home on foot, by hackney coach, or by the omnibuses that had begun to operate along the principal London routes in the years just before Eliza Grimwood's death. The terraces and courts running back from the main road housed a population considerably more mixed than the entertainment district's frontage might suggest, including tradesmen, watermen who worked the river crossings, lodging-house keepers, and women who, like Eliza Grimwood, supported themselves independently in a district where a theatre crowd represented a reliable source of custom. The economic position of a woman in Eliza Grimwood's circumstances within a district of this kind was one shaped by the absence of other reliable means of independent income available to unmarried women of the labouring classes in 1838. Domestic service, needlework, and a small number of trades represented the principal alternatives available to such women, each typically offering wages considerably lower than the earnings a woman in Eliza Grimwood's occupation might command in a theatre district frequented nightly by playgoers with money to spend. The record's description of her as a woman of sober habits who had saved money from her earnings reflects, within this economic context, a degree of independent management of her own affairs that a woman confined to service or needlework would have found difficult to achieve on the wages such employment generally provided. The metropolitan newspaper market of 1838 which seized upon the killing at Wellington Terrace with the appetite it customarily showed for reports of violent crime within the capital, was itself a market of considerable size and variety, encompassing daily papers read chiefly by the propertied and professional classes, alongside a growing number of cheaper weekly papers aimed at a broader readership across London and its suburbs. A killing of the kind that occurred at Wellington Terrace, involving, as it did, an independent woman, a long-established domestic partner under suspicion, and an unidentified foreign client who vanished without trace, offered precisely the combination of mystery and domestic intimacy that such papers found most reliably drew readers. It was this appetite, sustained across the weeks following the inquest, that carried the case beyond the immediate neighbourhood of Wellington Terrace and into the wider public consciousness of the capital, in a manner that a killing confined to more private report might not have achieved. The absence of a dedicated detective branch within the Metropolitan Police in 1838 meant that an investigation of this kind proceeded very much as it would have in the years immediately following the force's establishment in 1829, relying on divisional officers whose ordinary duties centred on preventive patrol rather than on the specialised investigation of serious crime. A detective branch would not be formally established within the Metropolitan Force until the middle of the following decade, and even then in a form considerably smaller and less developed than the investigative apparatus that would exist by the century's final decades. The officers who examined Wellington Terrace in the days following Eliza Grimwood's death worked, therefore, without the benefit of any institutional structure specifically designed for the investigation of a killing of this complexity, relying instead on the ordinary tools of statement-taking, local inquiry, and such physical observation of the scene as their training and experience allowed. The theatre Eliza Grimwood attended on the evening of her death is not named in the surviving record, though the Waterloo Road district in 1838 offered several possibilities within easy walking distance of Wellington Terrace. The Royal Coburg Theatre, which had opened some 2 decades earlier, close to the southern approach of Waterloo Bridge, had by this date taken the name of the Royal Victoria Theatre, in honour of the young Queen who had come to the throne the previous year, and it stood among the principal places of evening entertainment serving the district. Astley's Amphitheatre, somewhat further along toward Westminster Bridge Road, offered equestrian and spectacular entertainments that likewise drew large evening crowds from across the river. Either house, along with the smaller establishments operating in the immediate vicinity, would have released its audience onto Waterloo Road at a broadly similar hour, adding to the general dispersal of playgoers through the surrounding streets that characterised the district on any evening when a performance had been given. The audiences drawn to these houses were themselves a mixed body, ranging from the more prosperous patrons who occupied the boxes to the considerably larger numbers who filled the pit and gallery at prices within reach of tradesmen, clerks and labourers, together with the soldiers and sailors on leave, who were a familiar presence in a district close to the river and its traffic of shipping. It was from among this broad and varied evening custom that a woman in Eliza Grimwood's occupation drew her livelihood, the theatre crowd representing a source of income considerably more reliable on most evenings than any equivalent number of passers-by might have offered in a district without such places of entertainment. The presence of an unidentified foreign visitor among such a crowd, a man perhaps unfamiliar with the city and its streets, would not in this setting have been a circumstance likely to draw particular notice from those around him, a fact that may account in part for the difficulty the subsequent investigation encountered in tracing him. The streets immediately surrounding Wellington Terrace, in addition to their residential and entertainment character, included the ordinary commercial life of a Lambeth thoroughfare in 1838, with shopkeepers, provision sellers, and the keepers of small taverns and coffee houses catering to residents and to the passing theatre trade alike. The New Cut, a street of considerable local commercial importance, lying not far to the east of Waterloo Road, had by this period established itself as a significant site of retail trade for the surrounding parishes, its stalls and shop fronts offering the ordinary goods of daily life to a population that had grown rapidly across Lambeth in the years since the opening of the bridge. It was within this dense and commercially active setting, rather than in any more isolated or rural corner of the metropolis, that Eliza Grimwood conducted her daily life, and that her death, when it came, was so quickly known and so widely discussed. A house of the kind occupied at Wellington Terrace in 1838 would ordinarily have consisted of 2 or 3 stories above a basement or ground floor, built in the plain brick terrace style that characterised much of the residential construction undertaken across Lambeth in the decades following the opening of Waterloo Bridge. Such a house might be occupied by a single household or divided into separate lettings, with individual rooms or floors let out to different occupants under arrangements made directly between landlord and tenant or through an intermediary. A woman in Eliza Grimwood's occupation, maintaining a household that included a long-term domestic partner in William Hubbard, would most probably have occupied such a house, or a portion of one, under her own name as the responsible tenant, a position that the record's description of her as having saved money from her earnings suggests she was in a position to sustain without particular difficulty. The parish rating system of the period required the occupier of a house or tenement to bear responsibility for local rates levied for purposes including poor relief, paving and lighting, and a woman occupying a house at Wellington Terrace under her own name would have borne this responsibility in the ordinary course of her tenancy, a fact that placed her, in the eyes of the parish administration, in the same formal position as any other independent householder, regardless of the source of her income. The Lambeth Vestry, the body responsible for parish administration, in this period, maintained records of rating and of poor relief that have not been identified among the sources gathered for this account as bearing directly on Eliza Grimwood's case, though their existence illustrates the degree to which even a woman in her circumstances was woven into the ordinary administrative fabric of the parish in which she lived. The night of the 26th of May fell within the final week of a month that, in London, ordinarily marked a turn toward the longer and lighter evenings of early summer, with full darkness not settling over the city until a considerably later hour than in the winter months, a circumstance that would have extended the period during which the theatre crowds along Waterloo Road remained abroad on the streets before the district settled into its quieter, late-night character. The gas lamps that lit the main thoroughfare would have been lit as dusk approached regardless of the lateness of the season, maintaining the road's character as one of the better illuminated routes in the parish long after the smaller side streets and courts running back from it had fallen into comparative darkness, a contrast that placed Wellington Terrace, set back somewhat from the principal frontage, in a considerably dimmer situation than the road it adjoined. It was into this seasonal and physical setting, a district balanced between the bright and crowded frontage of a theatre road and the quieter, dimmer terraces standing back from it, that Eliza Grimwood returned on the night of her death, and it was within a house situated in this quieter setting that she was killed. The record does not establish whether any lamp was lit within the house itself at the time, nor does it establish the precise hour at which she and her companion arrived at Wellington Terrace following the evening's performance. What the record establishes is the fact of her return, the presence of the unidentified man in her company, and the discovery, the following morning, of the injuries that had ended her life during the hours that followed. The killing of Eliza Grimwood, once it had passed through the columns of the daily and weekly press, was of the kind of case that in this period commonly generated its own separate literature in the form of printed broadsides, single sheets sold cheaply by street hawkers, and often illustrated with a crude woodcut depicting the scene of the crime or the principal figures involved. Such sheets, sold for a penny or less, circulated widely among a readership considerably broader than that reached by the established newspapers, and a killing of the character and notoriety of the Wellington Terrace case was a natural subject for this trade. The surviving sources gathered for this account do not preserve the text of any such broadside specific to Eliza Grimwood's case, though the general practice of producing them for killings of comparable public interest is well established for the period, and it is reasonable to record that the case would have circulated in this form alongside its coverage in the regular press, reaching an audience that extended well beyond those who could afford a daily newspaper. The appetite this case fed was not without precedent in the London of the preceding decades. Some 27 years earlier, in December of 1811, a series of killings in the Ratcliffe Highway district, on the opposite side of the river and considerably further east, had produced a wave of public alarm and press attention on a scale London had rarely seen, an episode that remained in 1838 within living memory for a considerable portion of the metropolitan population, and that had itself gone unresolved to the satisfaction of many who followed it, notwithstanding the death in custody of a man suspected of the killings. The Wellington Terrace case did not approach the scale of alarm the Ratcliffe Highway killings had produced, but it drew upon the same established public readiness to follow at length and in detail the progress of an investigation into a violent and unresolved London killing, a readiness that the metropolitan press of 1838 was well equipped to satisfy. The involvement of officers beyond the ordinary Lambeth division in the investigation of Eliza Grimwood's death is suggested, though not established with certainty, by the general practice of the period, under which a case attracting sufficient public and press attention might draw the assistance of Bow Street runners, or of officers attached to other divisions, working alongside the local constables and metropolitan police officers with primary responsibility for the parish. The surviving record does not name any officer beyond the general reference to the Lambeth Division's involvement, and this account does not assert a more specific attribution than the sources allow. What can be said is that a case of this notoriety, occurring as it did within a highly visible and heavily trafficked district of the metropolis, would have received a degree of official attention considerably beyond what a comparable killing in a more obscure or less populous part of London might have drawn. The household at Wellington Terrace, once the investigation had run its course and William Hubbard had departed for the United States, does not reappear in the sources gathered for this account. Whether the house continued to be occupied, whether any family connection of Eliza Grimwood's came forward to claim her effects or to see to her burial, and where she was in fact buried, are not established in the surviving record examined for this account. These are gaps the available sources do not close, and this account does not attempt to close them with invention. What remains certain is the sequence of documented fact already set down: a woman established in her own name at Wellington Terrace, a household shared for close to a decade with a cousin dependent upon her earnings, an evening at the theatre, an unidentified companion, a killing during the night that followed, a coroner's verdict naming no one, and a literary afterlife that would, within the following year, place a fragment of her story before a readership considerably larger than any newspaper of 1838 could reach on its own. Oliver Twist appeared in monthly instalments within Bentley's Miscellany, the periodical Dickens edited during this period, and the chapters describing the murder of Nancy were not published until early in the following year, some months after the killing of Eliza Grimwood had already passed through its investigation and its coroner's inquest. The interval between the killing at Wellington Terrace and the publication of the chapter in which Nancy meets her death has been read by students of the novel as consistent with a connection between the two, the timing allowing for the case to have entered Dickens' awareness through the press coverage it received in the period during which he was composing the later portions of the novel. This reading rests on the observed sequence of dates rather than on any surviving letter or notebook entry in which Dickens names the case directly, and it is presented here on that basis. The scene depicting Nancy's death became, within Dickens' own lifetime, one of the most discussed passages he ever wrote, its reputation for violence and pathos growing rather than diminishing across the following decades. Some 3 decades after the novel's original publication, Dickens began including a reading drawn from this material, generally referred to as Sikes and Nancy, among the public readings he performed in the final years of his life, readings in which he took all the parts himself before large paying audiences in Britain and on one occasion in the United States. Accounts of these performances describe them as having an unusually powerful effect upon those who attended, with members of the audience reported to have fainted or to have left in visible distress during the passage depicting the killing, and Dickens himself is recorded as having found the performance physically exhausting to deliver, owing to the intensity with which he approached it. Members of his own circle are said to have expressed concern over the toll these readings appeared to take upon his health in the period shortly before his death in 1870. This later history belongs to the reception of the novel rather than to the historical record of Eliza Grimwood's own case, and the connection between the two rests, as already noted, on the proximity of dates rather than on any documented acknowledgement by Dickens of a direct source. It remains, nonetheless, a documented and frequently noted feature of the novel's history, discussed at length within modern scholarship devoted to Dickens and within the modern study of the Wellington Terrace killing itself, and it stands as the principal channel through which any fragment of Eliza Grimwood's story has continued to reach readers and audiences long after the coroner's jury returned its verdict in the summer of 1838. No comparable continuous local memory of the case appears to have persisted within Lambeth itself, in the manner that some other killings of the period retained a place in local tradition. What has persisted instead has been carried almost entirely through this literary channel and through the modern historical study built around it. The modern study devoted to Eliza Grimwood's case was undertaken by an author who has produced a series of works examining lesser-known killings and criminal cases of the Victorian period, drawing upon newspaper archives, inquest records, and Old Bailey proceedings held within the National Archives and the British Library to reconstruct cases that had, in many instances, received little sustained attention since the period in which they occurred. The reconstruction of the Wellington Terrace case within this body of work drew together the coroner's verdict, the contemporary press reports of the investigation and of Hubbard's questioning and release, and the surrounding social and topographical detail of the Waterloo Road district in an effort to present the case in fuller context than the scattered contemporary sources alone would allow. It is through this modern synthesis, more than through any single surviving contemporary account, that the sequence of events set down in this record has been preserved and made accessible to later readers. The case, considered as a whole, occupies a position within the broader landscape of unresolved Victorian killings that is distinct from the more widely remembered cases of the century's later decades, arising as it did in the earliest years of the Queen's reign, before the development of the investigative methods and forensic techniques that would, by the century's end, allow at least some killings of comparable difficulty to be resolved with greater confidence. The Wellington Terrace case stands, in this respect, as a document of the limits of criminal investigation in London at a particular historical moment, a case in which a household of only 2 established occupants and a documented final visitor nonetheless produced no resolution. Notwithstanding sustained press interest, a formal coroner's inquest, and the questioning of the person the investigation regarded as its principal suspect. The case of Eliza Grimwood was the last of these 3 cases to enter the historical record. The identity of the perpetrator was not established. No conviction followed, none was ever sought.